You can watch our program on Sunday afternoon at 1 o'clock. It's again repeated on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com, and we appreciate phone calls from parents. We're not attorneys, but we like to try to help you with our advice over many years of experience. My number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. We want to be as helpful as we can. That's part of our task here at the CPI report. We want to help you specifically in areas of false child abuse reports. There are some other tangential areas in which we're able to offer some hints, but because we're not attorneys, our legal advice is related primarily just to hints. Don?
why did you emphasize that we want to help people on the abuse report issue? Why is that such an important issue?
Well, that's part of the mission of Vocal, to assist others who may run into problems.
Wouldn't it be just as well to help them after they've had their parenting rights terminated?
Well, I'm not sure where you're going with that line of
I'm just saying that I believe that...
Tell us the rest of the story.
The report is one of the key issues. If you don't take care of that report, then you're going to be haunted with everything on down the line that DHS wants to pour out on you, and it's seemingly the last thing that an attorney is interested in helping you with.
That report can be called, well, it used to be called an investigation report. They're a lot kinder about it now. They still run investigations, but they call it an assessment report now, because that's the kinder way of
gentler bureaucracy.
Yeah, right. By the way, the kinder, gentler bureaucracy, you know what that spells out? KJB. So KGB. So
well, we're in a generation that's forgotten who that is.
That's right. But since they tore down the wall, but part of our mission is assisting people on a one-on-one basis, giving you hints as to how you should protect yourself, and you have a perfect right to go into the courts. You have a perfect right to file papers. You have a perfect right to protect yourself from accusations and reports and so forth. And as Don indicated, those assessments are essential reports that you don't want to have maintained by the state. And so your response to that is terribly important, and it should be a response that is timely filed, so that you don't have to fight that battle of when, if it was within the 6 months or whatever. We're going to touch on that in just a little bit, but we're going to turn now to our courthouse consultant, and here's his name, telephone numbers, and a couple of websites. We kind of had to squeeze in a little extra A down there on that bottom one, but it's www.amatterofjustice. And the A Matter of Justice is, I think that's a national website.
Yeah, it's a national organization.
Right. So, and he's got a couple of clever quotes that we'd like to bring to you at this point. So here now, Terrance Walker.
Hey, thank you, John, for having me on the show. I'd like to start off the show by a couple little tidbits that we should be mindful of. We just had a Easter holiday here. A couple of good things here to know for the holiday here. One is about the 10 Commandments. The real reason that we can't have the 10 Commandments in the courthouse, well, you cannot post, thou shalt not steal, and thou shalt not commit adultery, and thou shalt not lie, in a building full of lawyers, judges, and politicians. That would create a hostile work environment.
Thanks for bringing that out. Very good.
Something else about the Constitution we should remember. Well, they keep talking about drafting a Constitution for Iraq. Well, why don't we just give them ours? It was written by a lot of really smart guys, and it's worked for over 200 years, and we're not using it anymore. So why not give it to them?
Thank you, Terrance. That's really good. Let's look into a little bit about this business of what to do when you get a child abuse report. How do you go about resisting that child abuse report? Well, there's some steps to that. If you're going to resist that child abuse report or assessments or whatever they currently call that bunch of paper, usually 6 to 10 pages long, and they like to put on all kinds of junk into the irrelevant information into that report, and they like to explore your history, your background, and how you were raised as a child. And if they've got a physical abuse report that they want to do, they want to know how you were disciplined as a child and all kinds of things like that. And if you're ever involved in something like that, be extremely careful. If you consent to an interview with the social worker regarding an accusation of child abuse, be careful that you do not get outside of the boundaries of the specific allegations against you. They love to do what Don laughingly calls fishing expeditions, and they are indeed fishing expeditions. What they don't have in terms of accusations from somebody else, they can pick up from your own tongue.
Who's the fish that they go after, John?
Okay.
Parents and children.
That's right. Well, here are some things that you need to do if you get a child abuse report. And this first step, you must do this within 6 months of receiving that report. 6 months sounds like a long time, but it sometimes goes by very, very rapidly, and some people just simply forget it. And once they find out that the 6 month limit is up, they think that's the end of it. Well, it really isn't, but you're best off to file that on a timely basis. Otherwise, we have to fight other routes. Other people have gotten in there after 6 months, but there's no real reason for you to have to roll up your sleeves and to fight for things that aren't really all that necessary. File it within 6 months. You don't have to fight that particular battle.
I suggest you file it within 1 month. It's simple to get the ball rolling.
Well, and we'll show that in just a little bit about just how to approach that. The first step is to request expungement and an evidentiary hearing. Why don't you show us, Don, the what we need to do in order to get something like that started? We need to contact the Department of Human Services, and you got such a busy sheet here. I don't know if I can get it all on the screen at once.
We contact Rhoda Harris. She's responsible for taking care of this situation.
Okay.
But you got to contact her or she can't help you.
Right. So, and the simplest way to do that contact is to take that shortcut at the bottom of the page, the HTTP snipurl.com /9FAR, F-A-R. And that will bring up a, I don't suppose you have a copy of the form that it brings up, do you, Don?
No, not handy here.
We should have had that ready.
Takes about 5 minutes to fill out somewhat simple questions and then send it in.
Then can you send that in by computer, Don?
Yep. When you bring it up there, you just fill it in on your computer and hit the send, and then you want to follow through. in a few days to make sure that Rhoda has it in her computer. Okay, John?
Okay, so that's the first step you need to do, and you need to do this within 6 months of getting that assessment report. Those assessment reports can build up very, very rapidly, and in the meantime, make a list of all of the things that you want from the Department of Human Services, and you can probably tell some of those things that you're going to require in your defense based upon what you read in the report. So read the report very carefully, and if they talk to certain people, you want to know the name and contact information of those people so that you can consider subpoenaing those to an evidentiary hearing. Now, some of these terms that we're going to be using may be new terms to you. The evidentiary hearing is the first opportunity you have for what they call a fact-finding mission here, and that is to get everything together and to discuss it before an administrative law judge. That's another new term, administrative law judge. It's a misleading term because they're not administrators, they're not lawyers, and they're not judges, so they call them administrative law judge. But that administrative law judge does something for you with respect to bringing forth a report after he or she looks at and hears all of the evidence in the case. It's a fairly informal process, but it's highly controlled by somebody from the Office of the Attorney General to make sure that DHS doesn't lose the case. So they assign a high-priced attorney to gather that information and to block whatever efforts you have. But you have a right. You have a right to all of the information that is brought forth against you. You have a right to subpoena any individual who contributed to that report. Don?
It's interesting you quote the phrase, DHS doesn't want to lose the case. I thought DHS was there to help families.
Yeah,
It just seemed like that they're just it's not helping families for sure.
Quite a bit of the emphasis here is to protect children, and that's where the agency should be getting or should be directing its attention and its efforts and its budget and everything else. But much of what they do has nothing to do with child protection. It has to do with extending the borders of their tent, that is, making it larger and larger, making it influential over more and more individuals, and they're doing that really well, expanding that all the time.
Good for DHS.
And, there's a number of things that that have nothing to do with child abuse reports, and you may hear our courthouse consultant talking a little bit about that sort of thing, because a lot of what they do doesn't relate to child protection. It simply relates to digging their heels in and sort of taking over in a family situation where they need not be. And he may be pointing out in a story, in a recent story, where were these people? You know, why weren't they around? Why aren't they looking into cases like the Cedar Rapids case? They're just getting around to it now in the Cedar Rapids case to doing a child abuse report. Why didn't they protect that child? Why didn't they warn the parent that there was somebody out here? Well, they do that only in the most innocent cases where the guy is really a problem. They may not get around to warning those folks. Well, let's take a look, Don, back at that other sheet where we were a moment ago. We'll need to expand that just slightly. Okay, once you have that evidentiary hearing requested, you may not get it immediately. It may take 6 months before you come up for a hearing. But like I say, you have every right to explore every issue that is involved in that case. And there was a Iowa Supreme Court ruling that a friend of ours went through, and he did a magnificent job on his own of taking his case to the Iowa Supreme Court and providing that the Supreme Court they did a real good job of they did a real good job of pointing out that you have a right to look into every single issue regarding your case. Okay, if you do not get from that proposed decision the answer that you're looking for, that is to have the case expunged, then you can request a review of your proposed ruling from the ALJ, but you need to do that to the Director of Human Services, Kevin Concannon. Request a review of your proposed ruling from the ALJ. He's not likely to go against the social workers that are in his employ, so I don't know why we have this as a requirement, but it is required. From what I understand now, it's a requirement that you get that ruling from the director, and that forms in what they call the agency's final decision. Then you have to pull a $100 bill out of your pocket, and if you don't like that particular decision, and file a petition for judicial review. And that's under 17A of the code, judicial review. So, and that requires that you file that in district court. That will give you an opportunity not to argue the case over again, but to present any errors that the ALJ made in making his proposed decision, or any errors that the Director Concannon made in making the final agency decision. So judicial review is covered under 17A, Chapter 17A of the Iowa statutes, and you need to read that over very carefully. It's fairly simple language. The reason I say that is because I could understand it. You need to read that very, very closely, because that spells out what your steps are. And one of those steps is, if you don't like what you get from the judicial review, then you can file an appeal with the Iowa Supreme Court. And this is where you're going to need some help from someone who's been in that route, because that is not a real simple case.
But you do encourage them also to give us a call every step of the way, though, don't you, John?
That's correct. We'll try to. We can't do we don't have the time and staff to help you do the appeals, but we can show you the steps, and you can also get from the clerk of the Iowa Supreme Court. That's over in that $38 million marble mansion over on East Court. You can get a series of instructional booklets that will show you how to put together the brief necessary for them to look over the whole thing. And they'll look over the issues that you tell them to do.
Are you sure about that?
Well, that's within the structure and intent of the code.
Okay. That's not what it really happens, though.
That's not what really happens, because they operate under a different principle. They operate under a principle of judicial independence, which means the same as it does when your 2-year-old puts her hands to her side and said, "No, mommy, no." That's called.
I'm going to do it my way.
That's called infantile independence. But then when you grow up, you go into judicial independence. So the judiciary has, as a part of its general character, something called judicial independence. And what that's supposed to assure you is that nobody is going to push them around. Nobody is going to march up and down. And it probably is not a good idea to picket the appeals court. out of respect for that whole concept of judicial independence, I've seen them do things like that in the U.S. Supreme Court, and I think it's a little silly because the Supreme Court likes the idea of thinking for themselves, and they should. You certainly wouldn't. You'd really get in trouble if you did that outside the jury room, for an example. March up and down with picket signs outside the jury room. They'd get you for jury tampering if you did that. So some of these processes need to go on within the structure. It may not be precisely the way you want it, but I think when you play in their courts, you play by their rules, and you can sometimes win if you play by their rules. And if they don't play by the rules, you need to get that into the record. And the record is a magic word here. The record means what is it that's being preserved for review by a higher court. So you have to be very careful of what goes into the record and what is restricted from the record. Okay, you've got some stories there.
Didn't mean to take you off the subject.
Okay, go right ahead.
Yeah. I think that the big news today is it's March 30th, and they've just released an opinion, 11th Circuit Court of Appeals, which is one of the 13 Circuit Court of Appeals where people hear their appeals in the federal courts, directly below the Supreme Courts, of course. One of the big news today is Terry Sheive, who's been in the news here for about 2 or 3 months now, really big, especially the past couple weeks. She's been removed from the feeding tube. She's probably going to be dead by the time this program airs. She has her final appeal in front of the 11th Circuit was actually just dismissed a couple hours ago. I thought I would touch upon that because there was so many issues that arose not only out of the fact of her being removed from the tube. There's very controversial issues, whether it's a right to die, whether it's the husband has a right to determine whether she should die, whether the parents have a right to question that. There's just so many issues that arise out of that, and then to make it even more interesting, with this 11th Circuit Court opinion today, I think arises a whole lot of other issues, legal issues, that is. And since that's my area, I thought I would touch upon some of the things that arisen in there. Well, to give a little bit of backdrop, March 30th or March 20th of this year, 10 days ago, Congress and the president rushed into law an act to basically give Terry Sheive's parents a right to litigate some more concerning whether or not their daughter would be actually starved to death from having this feeding tube removed. From that ensued about 10 days of litigation. I mean, they went to almost every court that they could go to in this past 10 days trying to save their daughters' lives. But the thing is, there was an opinion in this opinion which basically denied the right, or denied the parents a hearing, or denied them the action that they were seeking in federal court, which was granted specifically by an act of Congress and the president. One judge's specific opinion in this, there's a couple of them that really bring to light some of the problems that we all face in the federal judiciary. There was only a few judges. There was one judge that made a comment, and then there was another judge, a couple other judges that made a comment. One that I thought would bring to light some of the not only the problems in this case, but the problems in all the cases that go into federal court, was a concurring opinion of Judge Birch of the 11th Circuit Court of Appeals. he is now when I say concurring opinion, I don't want to confuse people out there. Concurring opinion is one that agrees basically with the result. You can concur in the opinion, but you can not concur. Sometimes you can concur in the result. Concur makes basically they agree with it. But anyway, he goes on to state that he concurs in the denial of the rehearing of the case because any further action by the court or the district court, which is a court under them, would be improper. And he says, as an axiom in the study of law, is that hard facts make bad law. The tragic events that have afflicted Mr. Sheive and that have been compounded by the resulting passionate inter-family struggle and media focus certainly qualify as hard facts. And while the members of the family and Congress have acted in a way that is both fervent and sincere, the time has come for dispassionate discharge of duty. And this really brings to light, this next sentence brings to light some of the frustration that the judge has with the outroar against judges. A popular epithet directed by some members of society, including some members of Congress, toward the judiciary involves the denunciation of activist judges, and he puts that in quote. I'm sure you've heard that terminology before. Well, an activist judge is one that basically delineates his authority to dictate what the law is, no matter what it actually says. Generally, the definition of an activist judge is one who decides the outcome of a controversy before him according to personal conviction, even one sincerely held, as opposed to the dictates of law as constrained by legal precedent and ultimately our Constitution. In resolving the Sheive controversy, it is my judgment that despite sincere and altruistic motivation, the legislative and executive branches of our government have acted in a manner demonstrably at odds with our founding fathers' blueprint for the governance of a free people of our Constitution. Since I have sworn as they have to uphold and defend that covenant, I must respectfully concur in the denial of this request. And he concludes that the act that they've made to grant the parents a right to a hearing in federal court is unconstitutional. And he does so on a number of different basis. One, he says that it violates the separation of powers. And there's a couple other things that he had beef with.
And that means that Congress can't address the courts on their grievances.
Yeah, well, the basically his he does kind of have a basis for that. There's a dissenting opinion, which I'll read in a minute here, that basically I think does a better job in demonstrating that it wasn't a separation in power issue. It was a one in which I feel that the judiciary feel that it should have all the power. I think that was more of the issue. They should have all the power instead of a separation of power. They think that they should have the right to dictate different standards and regulations. But what he had problem with, and which I'll list out here, and then I'll get into why I feel that it's his reasoning is not justified. And I do think that this guy is an activist judge. I will say that. But what he basically says is that the act, when he's complaining about the act, he complains about the fact that the act only provided jurisdiction under Article 3, Section 28. And he said if it did, he said the act would be in violation of the principles of separation of power. And he said that the Section 2 of the act, which was the Terry Sheive Act to grant this this right to a legal matter, he said that it shall provides the district court tells the district court that it shall engage in de novo review. In other words, it should review the allegations, constitution of federal claims of Terry Sheive's parents and Terry Sheive's issues, all new, de novo. That's what that means. Number two, the act also says the court shall not consider whether these claims were previously raised, considered, and decided in the state court. And it says that the court shall not engage in abstention in favor of state court proceedings, and shall not decide the case on the basis of whether remedies available in the state courts have been exhausted. So, in other words, he's basically saying that these four things involve a separation of power, which I have to wholly disagree with based upon the reasoning of the dissenting judge opinion in this matter. He basically says that this is a violation of our powers. Well, page 27 of the opinion, which is the concurring opinion, or the dissenting opinion, I think Judge Birch did a really good job in laying out how the previous judge was wrong. And he lays it out like this. He said, Judge Birch now argues that this court lacks jurisdiction to entertain this case due to constitutional infirmities in the legislation enabling federal review of this case. And he said, I believe it's fully within Congress' power to dictate standards of review and to waive in specific cases non-constitutional abstention doctrines. Well, to give a backdrop of what he's talking about and these abstention doctrines and all this stuff, this is judge-made law. So there is no right for a judge to sit there and say that this is a separation of powers issue. Congress has the power to make the law. Now, if they make a law that conflicts with judge-made law, I think that it is fully within their capability, since they have the constitutional authority, to make that law, and that law should supersede any judge-made law. Well, these abstention doctrines and the failure to exhaust, you didn't exhaust all the state court remedies, these sort of doctrines were judge-made laws basically created to eliminate a lot of their workload. Now, if Congress wants to do away with this judge-made law, then it has every right to, and that's basically what he's saying. Now, he goes on to state how, and he cites a lot of authority, which the other judge failed to do, that was right on point. He says, this case is not a case of separation of powers. He said, instead, Congress has prescribed a particular approach to a particular problem in the general domain of federal jurisdiction without presuming to dictate in any respect our performance of a court's essential function, which is to say what the law is. And he cites Marbury versus Madison, which is the founding case of judicial review. It is in this domain that this Supreme Court has jealously guarded our power against intrusion by Congress. Here the Congress has attempted only to do what has been established to be within the power to dictate our standard of review, the effect of a state court judgment on that review, the application of prudential abstention doctrines, and the effect of exhaustion requirements. I know of no case barring Congress from so dictating, and Judge Birch does not even cite any. I think that we do have to really chide Judge Birch even further in the fact that he is a activist judge and making this leap of logic and this stretch when he cannot rely on any authority whatsoever to basically say that Congress does not have this right to. And at first I thought that this might have been an overreach, and it may have been an overreach for all these politicians to fly in and make a law over this issue or this lady, but I do have to say that they had every right to do so, and once again our judges failed us in deciding that judge-made law is superior to what the Congress had made. What are your thoughts on the matter, John and Don?
I'm speechless. John, pass it to you.
I hope I didn't confound you with my legalese there. I'm not trying to talk too confusing there, but it happens in case after case, and I've seen it in so many cases, especially when you get to the federal judiciary. They say, well, you didn't raise your case in state issue. That's one of the things, one of the legal hurdles that they make you overcome, which is what they were talking about.
You didn't file on time.
Yeah, and then this standard of review. Well, we're going to defer to the state court judgment. That's called a standard of review. A lot of times they do that. That's another hurdle you have to overcome. The other hurdle you have to overcome is called the Ruckman-Feldman doctrine, which that state law, we're going to just let the state law or the state court decision, that is, basically saying that the state law decision or the state court decision is going to be our decision. We're not going to interfere with that. So, these are all judge-made laws, and I think that we have a terrible thing on our hand that we have judges that basically say that their judge-made law is superior. So what is the Congress going to do now if they cannot enact legislation to confront these doctrines? And here we have a judge that claims he's not an activist judge say that that's separation of power, when there's no case saying that judge-made law, Congress cannot basically end judge-made law. I think that we need to end judge-made law.
They crafted that really well to avoid, I think, that criticism of telling the courts how they were going to rule. They simply said, you are to take this case de novo.
Exactly.
You're to review it. And from what I understand, they didn't do it.
Exactly. And I think that they have enough lawyers there in Congress to instruct them as to what's constitutional and what's not constitutional. And I think in this case, they may have got it right. Sometimes I know they go beyond the bounds of constitutionality. But this case, as so eloquently pointed out, with citations to authorities by the dissenting judge in this matter, this case is one that fit right within the mold of their duties in Congress to enact laws.
I think the judges are putting themselves up on a pedestal and claiming to be God. And the Bible says, pride goeth before a fall. So,
well, they have a lot of pride, and I think it's they're basically calling Congress arrogant, but I think that the old adage that what's don't call it's like the pot calling the kettle black, basically.
Right.
Because this judge basically is making a leap in logic and a stretch to say there's separation of powers. He was the only one that signed off on that opinion, which I do have to add. But there were other silent judges, which they basically wrote a one-sentence denial. They didn't want to put anything out there, probably for future repercussions, because the Congress does have the power to basically strip them of some of their authority as well. And I think
not only strip them of their authority,
there's going to be some fallout.
They can close their buildings.
Exactly, and they can make it a lot harder for them
and suspend their salaries. So, when you have this war between the branches of government, and I think we need to respect the authority of the various branches. That one branch shouldn't tell the other branch what to do. But when you have the courts who are assessing a problem like this, going far out of bounds to adopt an ideology that doesn't run parallel to American justice, I think that it does behoove the Congress to look into one of the most favorable things I saw with respect to Congress entering this is that as a citizen, we have the right to address Congress based upon our grievance. That's the First Amendment, or first article to the Constitution, is our ability to address our grievances to Congress. I, along with a number of other individuals, and I think there are a number of agencies and number departments and everything else that felt uncomfortable about Congress picking up on something like this, calling everyone in from their vacations and everything else in order to discuss this matter. And the matter, in our opinion, the matters should be settled at the lowest level possible. But this was such an entrenched, fervent battle that I think that it merited the attention of Congress. I hated to see the president have to leave Crawford, Texas, in order to come back and to sign a document, and so that he could expedite this thing. I think that maybe it's chuckle time here, but I think that the Congress should have told all the judiciaries, all the members of the judiciaries involved in the local district court, in the 11th Circuit Court, in the Supreme Court, the Court of Appeals, and wherever, that they could not have any sustenance so long as the case persisted in the courts, or until the Sheive lady managed to get her, Terry Sheive, managed to get her sustenance returned. I think that would.
Now, what do you mean when you say sustenance? I don't want
In
you
other
to
words, I don't think
everybody out there.
if a judge is in charge of looking over a case de novo, I don't think that he should say, well, we're not going to have this case out in an hour. Well, you can't write 30 pages in an hour, you know. You might want to give him 4 or 5 hours to do it. But when the president travels all the way from Crawford, Texas, to come back and to sign the congressional action, one would think that perhaps they ought to get on their horse and get the job done. In the meantime, they should have nothing to eat and nothing to drink. I think they would begin to recognize the importance of sustenance, and I don't think they recognize that. And I would think that for a person who is incapacitated in this fashion, and that's all she needs, is something to eat and something to drink. Very, very fundamental. Yeah. And I think that anybody who was, including the governor and the president and so forth, should have gone without eating until the matter was resolved. And I think you probably see a fairly rapid pursuit of a resolution if everybody forgot to eat for 13 days. I think this thing went on far too long, and it's more than just a right to life case, in my opinion. I think there were some real legal errors here. When Congress tells the courts that they are to handle this case anew, that was a grievance brought to them by Terry Sheive's parents. They had a right to get an address of grievance. And this was the most appropriate, and I think Congress acted appropriately, not to tell the courts how they were going to rule or to lay down the steps by which they ruled. They simply said, look at the whole thing.
Yeah, and that's just basically a standard issue.
And they didn't do it.
Nope, they failed.
They failed to do their job. They took in hearsay information that would never have passed muster in any other situation. If a policeman stops you in on a traffic case and says, "I want to see your license," you say, "Well, I think I have one, but it's home." "Oh, well, that's okay. You know, you do have one, don't you?" "Oh, yeah." No, he wants to see the documentation. And if Terry had made some kind of a declaration, a specific declaration, the only way we can make that determination without her actually testifying to it in court is to look at the document. If the document is absent, then the declaration is invalid.
Yeah.
And that was one key issue that they completely ignored in this matter, don't you think, Terrance?
And I had a comment on that. I do think that, going back to not the legal issue but the moral issue, I do think that, you do have a right to die. I mean, I wouldn't want the government telling me whether or not I could die or not. And what they're going to do if I decide to die. Are they going to come take my life again? So
right.
It's just insanity. But I do think that a person should have a right to die. But at the same time, if you're going to entrust members of your family to basically make that decision for you, should you be in a brain dead situation or a vegetative state, like they say, I would like to have, it should have been enacted in law, if it's not in some states, that there should be something in writing that says that if you're brain dead, then, we give so-and-so the permission to pull the plug.
Most everything else is based on writing until we get to this case.
Right. Yeah. Why does he get a free pass?
Yeah. Well, and this, he said, she said.
Yeah. Right. Right.
And you had a comment about that brain dead.
Yeah.
You don't want judges deciding. You know what I'm saying. When we was talking about we wouldn't want to have a judge decide whether or not you're brain dead. We'd want your loved one to decide whether or not you're brain dead.
And I understand there's money sitting there waiting for her to die. Michael will collect a big fee for that.
That's a suspicion, but
he's gotten like $700,000 from the accident, and I think $300,000 more from some other separate lawsuit as well. So he had close to $1 million. I don't know where you're sitting at now, being as how he probably had to pay these doctor bills all these years, but.
Right.
You could turn that over to the government. The government will.
Well, those are pretty. Those are pretty well covered by the original settlement. Now there was also a settlement in loss of consortium, they called it. Well, I don't know how you can morally ask for a loss of consortium while you're sleeping with another woman. What is the consortium that relief that he was seeking from this? Disabled woman, if he had found alternative consortium. What's he looking for, for goodness sakes? Well, I think there were so many problems in that case.
There are so many issues. I think that's why the media picked it up and ran with it, but I think there's more other pressing issues as well to deal with. This will probably be a forgotten thing about a month from now.
Right. Well, it turned into a melodrama almost, and but I think that it points up some issues of problems in our system.
Very big problems in our issue, not only ethically, I think, but like legally. Should Congress have the authority to tell the federal courts to basically not use these different standards and these different doctrines to prevent it from hearing cases? Because they do that, and I understand the federal courts are burdened, but they're there for a purpose.
That's right.
If they're there for a purpose and they're supposed to be there mandated by law, do your job. Don't make up judge-made law and doctrines to prevent cases from hearing the merits of different cases, so you can make your workload better. Every citizen, I feel, has a right to have their day in court, and here we have continuously here the past couple dozen or so years with these doctrines in place. We don't have a day in court anymore. It's
aren't we chipping away at justice though every time we invent a new a new little twist in the way the courts function like that.
I think they are.
Time limits, I think, are another real hazard in courts. You know, you got to file your appeal in 10 days, or you got to file your appeal in 20 days, and it's got to be in this kind of a format. The format and the timeliness should be secondary to something called justice. Justice shouldn't have to stand aside and be determined whether or not you dotted every I and crossed every T. In my opinion. Well, let's move on here. Congress has made its entrance into Iowa here, its presence known here into Iowa, and because once in a while they'll have hearings. And this is a hearing from the House Committee on Ways and Means. These are statements from Greg Hansen and Lisa Watkins of Hiawatha, Iowa. And Don's going to pick it up here in just a moment when we turn to page 2. But child protection has become an industry, these two say, and the contract the states entered into for federal grant money was contingent upon the states meeting many standards. The threat of cutting off funds if states didn't fulfill all the requirements has not been followed through by federal government, however. Until recently, these agencies used to fend off any correction or any decision unfavorable to them by simply saying that the politician was against child protection. Oh, that would be a terrible thing to say, you're against child protection? Well, that certainly would be sufficient to make you wonder, make you think twice. A few congressmen have experienced this McCarthy-era type demagoguery from the child protection industry. See, they've got all kinds of clever tricks like wanting to get into your house and you say nothing doing because I know something about the Fourth Amendment. And they say, but you don't have anything to hide, do you? That's the way they function. It's a childlike mentality, but that's what the Department of Human Services and agencies like them seem to gravitate toward. Now things for their industry have gotten bad enough that politicians don't have to fear this tactic of demagoguery as in the past. I basically don't think any government agency should remove kids or reimburse states for removing kids unless there is some very serious reason in that individual case to override constitutional rights of a family to be intact. Much like the Enron, the child protection has been too much motivated by funding streams and bean counting at the expense of ethics, fairness, and even responsible handling of money. The main data provided to the federal government to qualify state child protection agencies for federal money is in fact generated by judgment calls made by the agencies themselves. In other words, they police themselves. They check on themselves. They write their own report cards. Wouldn't that be nice if you could have done that all the way through college? You could have gotten, moved your grade up from an A- to an A+. All they have to do is call every case imminent danger, and when they remove a child from your home for clutter or a messy house, the federal government feeds them money for this, and caseworkers are immune from perjury, so they do it a lot. He probably should have said they lie a lot. Hasn't Congress ever noticed that child abuse and neglect is one term can for funding? What most citizens would consider to be child abuse is about 3% of all child removals. The vast majority of child removals are for neglect, not abuse. Neglect is a large catch, all that can range from drug addiction issues to simply a messy house. The percentage of cases where state agencies really don't know why the child was removed is most revealing, a percentage usually higher than 3%. In other words, statistically serious child abuse is statistically small enough to hide within the margin of error. Keep in mind that these numbers might be considerably less utility to the state agencies if the state agencies were not the ones reporting these numbers. We saw a case the other day where they had some numbers that were fairly high, and DHS come back and says, well, that's because we count some of the children twice. That's because they were reimbursed twice if they counted them twice. Another factor is that if child protection were to accuse 1,000 parents wrongly, an amazingly large number would find the overbearing, corrupt juvenile courts too much to cope with, almost terroristic in their approach, and would surrender completely, seeing the struggle as futile. I personally watched my fiancée fall prey to what I have dubbed the stipulation scam, where her own lawyer pushed her to stipulate without serious consultation, just 15 minutes of pressure before the court. You want to pick it up there, Don? 90 plus percent?
90+ percent of all cases are stipulated, a term in juvenile courts which is comparable to a guilty plea, even though the Judas lawyer says it was not, and all the effects are exactly like a guilty plea. Stipulations are generally not signed and rarely involve a document to consider or time to consider it. My fiancée only agreed to consider one, but her attorney agreed for her. She never saw a document to consider or signed any. So, it's just another example of how the courts, the attorneys, control the situation, and here you're trusting the system to rule in your favor, and you've got a court-appointed attorney doing that for you, or in this case they call him a Judas, quote-unquote Judas lawyer. Hey, you know what happened to Jesus before he was crucified? And Jesus even loved Judas. But Judas
sold him out.
Sold him out for 30 pieces of silver. And that's just about what the attorneys do to the parents in court. A judges association in one area openly and outright urged local family law attorneys to talk most families into stipulation to save on court time. No reference was made to guilt or innocence, which fits my experience. Child protection and juvenile court tread on a most precious liberty interest. 14th Amendment right to the Family Association.
We're going to look into this piece here in greater detail in future programs. So we thank you for stopping by, and thank you, Terrance, for showing up here. Okay, we'll talk